Section 34, we have proposed a separate ground for purely domestic arbitrations. This is arbitration between two parties, and it's the belief of the Commission that the legitimacy of judicial intervention in domestic awards is much higher than it has in respect of the international commercial arbitration. So we have proposed Section 34(2)(a). The ground is patent illegality appearing on the face of the award, but that is again restricted by the proviso, and the proviso provides that award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciating evidence. So there is a ground separately given for the domestic arbitration. And as far as international commercial arbitration is concerned, you will recall that in ONG's case, the Supreme Court expanded the scope of public policy. The unfortunate part is in India, in the present law, for all the three kinds of arbitration, that is purely domestic arbitrations, international commercial arbitrations in India, and international arbitrations seated outside India, the grounds are the same. So the public policy is a ground for both. So in Renu Sagar, the court interpreted the term public policy to mean three things. One, fundamental policy of Indian law. It's a policy of Indian law and not the Indian law. So for instance, in that case, the question was whether compound interest is permissible. The court said no, it is not opposed to fundamental policy of Indian law. The interest of India and the justice and morality. We tried to make this definition more tight in the sense that we deleted the reference to interest of India because according to the Commission, it is vague and capable of interpretational misuse. And we said, so it is only the fundamental policy of Indian law or the very basic notions of morality and justice. So what is a very basic notion of morality? The basic notion, if it violates a child labor law, anti-child labor law, it offends the morality because it is something about this, say in similar gambling or such disputes cannot come by of arbitration. Then then we dealt with this effect of Balco, which overruled Bhatia and Venture Global. So the issue was whether Part 1 would apply also to arbitration seated outside India. So surprisingly, the court said the spirit of the act to be looked into and said that it will apply even to the arbitration seated outside India. So Part 1 not only applied to the Section 9 but also to Section 34. And in one of the judgment, the Supreme Court said that it has the power to appoint an arbitrator in respect of a tribunal seated outside India. So Balco has put an end to this controversy, and Balco says that the Part 1 and Part 2 are mutually exclusive. But Balco has created two problems. The first problem is that what happens where the assets are located in India, and then what is the remedy of that party? So only an award can be enforced in India by way of a decree. An interim order of the tribunal outside India cannot be enforced in India. So if Part 1 is not applicable, then the party litigating in India or outside India has no remedy to protect the assets, protect its interest. So we said that the Section 9 and 27, which is about taking evidence or gathering material, would also apply to foreign arbitration seated outside India, but this can be excluded by the express agreement of the parties. And secondly, Balco said that the old law, which is a erroneous law, would continue to apply if the agreement was entered into prior to the date on which Balco was decided. So this would mean that this erroneous law would continue to govern the parties for decades to come. So we said only pending applications would be protected and not the agreements which are enacted early. Then the other challenge is this automatic stay of the award by simply filing a petition. So the first judgment was really in the context of section 42, where the court said that once the petition is filed, you cannot ask the party to deposit the money, some amount. And this was applied to section 9 by the Bombay High Court in Alphonse. So we have said that mere filing of the petition would not apply as a stay of the arbitration. Party has to apply for stay. And we have also provided that the party cannot move for stay or move an application under section 34 without prior notice to the other party, other side. And while granting stay, the court shall keep into mind the principles of granting stay of the money decree. So this automatic stay, we said that it should not be, it should be terminated. Then the powers of the tribunal. So section 17 confers power on the tribunal to pass interim measures, interim reliefs. But the courts have taken a view that this court order is not enforceable. And also I must bring to your notice that UNCITRAL is amended in 1976. And under the amended UNCITRAL, a large power is given to the tribunal, and we have adopted that kind of a scheme for section 17. And it is provided expressly that the order of the tribunal under section 17 shall be deemed to be order of the court and shall be executed for all practical purposes, and it will be enforceable as the order of the court. I may tell you that the Delhi High Court in Sri Krishnan versus Anand tried to find out a very novel way of enforcing the interim orders of the trial court by saying that if the order is violated, it will be deemed to be a default within the meaning of section 27. The party can apply to the tribunal to make a reference to the High Court, and High Court will treat that reference as a contempt. I don't think that's really with great respect to the learned judges, I think it's not a correct judgment. But anyway, we said that it should be enforceable as a order of the court. Then another issue is very, very striking, and that is the judgment of the Supreme Court in Radhakrishnan versus Mastro Engineers. Now, in that judgment, the court said that the arbitral tribunal cannot decide complicated question of facts or law or fraud and corruption, etc. Now, for that, Supreme Court has relied upon a judgment of the Madras High Court, which was delivered in the old law under 1940 Act. Unfortunately, this was followed with slight distinction in Bharat Rasiklal, which said that if the fraud is of such a type that it would vitiate the agreement, then the only court can decide that the issue of fraud. But in Swiss timing, Justice Ridger, sitting singly as a delegate of the Chief Justice, held that Radhakrishnan was not correctly decided. So we said, to put an end to this controversy, we have proposed amendment to section 16 that all the issues of fraud, etc., will be expressly arbitrable. Then the most vital issue is the neutrality of the arbitrators. See, we have developed a pernicious practice, particularly in the state government and with the public sector undertaking. They provide in the contract that their own officers, either sitting or retired officers, will be the arbitrators. It is as if saying that the party which says that he or she will be an arbitrator in the arbitration, and the Supreme Court upheld all these kinds of arbitration agreements on the ground that it is a party autonomy. See, there is a level of natural justice which cannot be breached even by the agreement of the parties. Otherwise, arbitrations won't have any meaning. So therefore, we said we have provided a system that we have borrowed this red and orange list from the International Bar Association guidelines on conflict of interest. So no employee can be appointed as arbitrator. Secondly, there are some situations where the arbitrator must disclose, that all those grounds are in proposed fourth schedule, where there is a conflict of interest. And there is another fifth schedule, if there is a conflict of interest of that type, then arbitrator cannot be appointed, that person cannot be appointed as arbitrator. And then another thing which we provided, that the arbitrator, the person must give a declaration, he may a retired judge or a lawyer or anybody, that he is in a position to decide the arbitration within 2 years, and also he will write the award within 3 months. That's so that he has to give an undertaking, whether it's under Section 11 or ad hoc arbitration. And we have also proposed some small amendments like definition of party, where we wanted to bring the definition of party on par with the Part 2, where it says that the party or any person claiming under it. Then we have also provided the arbitral tribunal, that the arbitral tribunal will have power to award interest, compound interest, interest on interest in the final award. So we felt that the Arora's case is wrongly decided. In fact, there are other judgments which says to the contrary. Then the last part which I would like to speak before you is really about the system of ad hoc arbitration in India. It exists only on Indian subcontinent. It's not there anywhere in the other countries. All the arbitrations are conducted by institutional arbitrations. Now we have arbitration institutions. The oldest one is the ICA, Indian Council of Arbitration. Then Delhi High Court Arbitration Center was started in 2009. It's doing well. Then we have arbitration center recently opened by Punjab and Haryana High Court, and one is going to be opened in Madras. There is also Nani Palkewala arbitration institution in Madras. I just visited one arbitration institution just recently, which is about to be started in Bombay. The Indian Merchants Chamber has created a very impressive infrastructure as an arbitration institution there. This is going to be started soon, and I wish that all these arbitrations are governed by the institutional arbitration. We tried to provide some encouragement to the institutional arbitration in the proposed amendment. First is, we said that whenever Section 11 application comes, the court must encourage the parties to go to the institutional arbitration instead of going to the ad hoc arbitrator. The cost of the ad hoc arbitration is too much. I just heard a story which I must mention before you, that this is about some party approaching a retired Chief Justice of India, and he said that he would be charging 3 lakhs per session, so 6 lakhs per day. So this party said that, sir, this is not a big claim, and he stated that the claim is so much and the counterclaim is so much. The moment the judge heard about the counterclaim, he said then it's double the fee. It will be 6 lakhs per session. So where are we heading really? So we said that the cost, when it goes via Section 11, there has to be we have suggested a model table. A very reasonable and decent fee structure is provided, but that is only in respect of the domestic arbitration. We do not wish to interfere with the international commercial arbitration, where the parties should be free to decide what kind of arbitration they want to choose. So this is one of the issues which we considered. So it is basically, it's ad hoc versus institutional. And lastly, I come to the conduct of arbitrations. It's amazing the way in which the arbitrations are conducted in this country. See, there is something called some formal hearings where nothing happens. This is just the arbitrator and arbitrators and the lawyers gather. They say there's some procedural directions are given for it's a sitting for 15 minutes or half an hour. And for that, huge amounts of fees are charged both by the bar and the arbitrators. So in international arbitrations, the arbitrators don't meet at these formal hearings. This all on the either mostly on the teleconference, and maybe on a video conference. But why we cannot adopt this teleconferencing? Why there should be such hearing? And I heard some very wrong practices being adopted by some arbitrators. I heard that some arbitrators would sit for half an hour and pass some order, but they will give the copy only in the second session because they can charge for the second session. So this is all, we should discourage these practices. We should have a very modern system of conducting arbitrations. We should not have the witnesses' evidence recorded in the arbitration proceedings. Secondly, I'm amazed at the way in which the cross-examinations are conducted in this country. It's as an arbitrator, I mean, there are some limitations. The lawyers cannot be stopped at every stage. But most of the cross-examination is about just the putting suggestions. And it's a complete waste of time. We are in that oral evidence importance is really not so much today, because most of the arbitrations are based on documentary evidence. So I wish that apart from the changes in the law, really it is time that for the retired judges, the lawyers to introspect and to decide how they can change the culture of the arbitration in India. I had a meeting with the Honorable Minister of Law and Justice on 2 occasions in this respect of this issue. And on both the occasions he asked me how this India can be made international hub for arbitration. I had no heart to tell him that the fault lies with mostly our community. So anyway, but so we should really consider about the changing our practices, and really in that event, I hope that India can attract a lot of arbitration work from outside. Thank you very much. Thank you.
I think it took a little longer than Justice Shah had thought it would to present his speech or presentation. So what we'll do is go back to the normal practice, which is that let all the other speeches also be made now. So may I now invite our friend Mr. Amarjit Singh Chanjok, who has worked on this in the team that in preparing the consultation paper, etc., on the basis of which the examination by the Commission had also begun. So after him, I'll invite some of the others. But I think we'll have to stick to about 10 to 12 minutes each.
More than that. Respected Chairman, my friends on the dais, respected seniors and my dear friends. Shankardass ji told me it can't be more than 12 minutes, so I thought of I was referring to me as 12. So it was peculiar to me that it had to be 12 minutes. We have already heard Justice Shah giving us the overall of what the Law Commission is proposing to do. Before Justice Shah took over as the chairman of the Law Commission, one had the occasion to look at all this. And we had done 5 seminars over the country to see who are the people who are actually practicing in arbitration, that they should be consulted to see what is the day-to-day problem to see before we proposed amendments. In fact, a draft act was already with the government when the matter has been brought back to the Law Commission. The problem that I see is that the Arbitration Act 1996 is generated by a computer. Either you adopt UNCITRAL completely or don't interrupt. You can't have something from the earlier act, something from UNCITRAL. So please don't have half-baked things. That was the first request that I had made in my presentation to the committee to say, either once we are saying it's uncitral model, then please adopt all uncitral and say that if there's any change in uncitral, this automatically becomes a change here. Take for example in uncitral we have section 27, article 27. There's no such provision here. There they say you can ask for discovery, you can ask for all those things which can happen outside. But there's no such provision in the Arbitration Act of 1996. There section 16, for example, here is appealable. And that's adopted in the English Arbitration Act, but we don't want to do that here. So the result is that if I'm challenging the very jurisdiction of the arbitral tribunal, then why should I go to the entire trial of arbitration and then go to section 34? And when it comes to 34, we say, no, the jurisdiction is limited. So the question was, you may have judicial intervention at an appropriate stage. Even on a section 14, for example, we talk of de jure and de facto, but one high court says I can intervene, other high court says only when you finish 12 and 13, then you go to 14. Now 13 says you must await for 34, 14 doesn't talk about it. So the first submission that we had made was that the arbitral courts and the arbitrators first must be those who have done arbitration and have read the statute 1996. I must place that on record of this galaxy of audience that unfortunately we are today not able to get, notwithstanding that the practice has become specialized, you'll find people doing only arbitration, only commercial, only competition law, only mergers and etc., etc. But when it comes to me, I don't mind looking at anything that comes my way, notwithstanding that I don't know the fundamentals of it. Therefore, when we are appointing arbitrators, I'm not even touching the expert part, because I don't know, when I didn't have the opportunity to hear the session prior to lunch, but my experience as a lawyer today, or even as a law officer, I saw, there was no tribunal in this country where we actually had an expert sitting on it, maybe barring one or two. Excuse my saying so, but how will that be an expert simply because he happens to be some joint secretary or somewhere in the ministry? Can't be an expert on the subject. Therefore, this time has come when we all will have to consider come back to a normal court. Maybe it is much better. The infrastructure is, you'll reduce quantum of money that you spend on justice delivery system. And this bogey of saying that we have a lot of delays going on in courts, that is only because neither we as lawyers want to assist the court, and unfortunately the court himself doesn't know anything about it. And let me give you a very small example by statistics. Except for Delhi, Bombay, Calcutta and Madras, part of it Bangalore, an arbitral court dealing with section 34 or for that matter 11 in all other parts of the country is once in a month. What do we do that? Company court, once in 2 months. Now, therefore, the question is today, please rotate your judges maybe for 6 months, 1 year to those jurisdictions where they are actually get exposure to this. And please, the bars have a larger responsibility to discharge, to tell their members what it is. We start a mediation center in 2006 in Delhi, and we found people today who have never seen criminal law, for example, or not seen a commercial law. As a mediator, he was ready to sit in the mediation. So one had to request him to recuse so that we can bring somebody who knows the law on the subject. Therefore, the question is, when you're appointing an arbitrator, please ensure that the honorable arbitrator knows what law is. That means Arbitration Act, the nuisance of it. That's the real problem is. And when the Chief Justice makes a roster, he must appreciate, he must have a judge who has done something in arbitration. A judge who has never even opened Arbitration Act 1986 made to sit on section 9. And how do we look at section 9? And then the worst part is the Supreme Court. I said that somewhere else, speaking at Mohali the other day, to saying that it is time the Supreme Court must learn now. We have been crying horse for section 34 and we have seen a judgment in 2014 again. Again enhancing 34. Saying as long as my judicial conscience says this, I will set aside the abort. Then what for have a statute? Then leave it there. Say judicial conscience satisfied, matter ends. Therefore, the Supreme Court will have to first lay down the law, the principles, how it wants to interpret.